Today's courtroom story is intense, emotional, and deeply complicated. A mother stands before the court after admitting she tampered with evidence connected to a deadly shooting. The case involves addiction, loyalty, and a desperate decision that may have made a tragic situation even worse. Prosecutors argue she knowingly removed a murder weapon, while the defense claims she was a struggling mother trying to help her son during a moment of panic. But the big question remains, was this an act of desperation, or a serious attempt to hide evidence in a homicide investigation? As the judge prepares to deliver a sentence that could change her life, every detail of what happened will matter.
Today in case 25-CR-1402, the State of Ohio versus Carla Ferrona. The defendant is present, represented by counsel Mary Catherine Corrigan. We were last before this court on January 26th when the defendant pled guilty to count 1 of the indictment, tampering with evidence with a 1-year firearm specification. Parties have had the opportunity to review the pre-sentence report and are prepared to proceed with sentencing today. Thank you.
Thank you. Anything you'd like to say at this time on behalf of your client?
Thank you so much, Your Honor. Your Honor, we would ask that the court consider imposing a minimum sentence or, in the alternative, a 1-year sentence on the underlying charge with 1 year on the firearms specification. In support of said request, we would highlight a few things for the court. Judge, I would ask that
Here the defense attorney begins laying out the central argument for leniency. Notice how the lawyer emphasizes that the defendant accepted responsibility almost immediately and never tried to deny her actions. In court, that type of cooperation can sometimes influence sentencing because judges often look at whether a defendant shows accountability. The defense is also highlighting her difficult life circumstances, including long-term addiction and mental health struggles. These factors don't excuse the crime, but they are often presented to show context. The goal here is clear: convince the judge that despite the seriousness of the offense, this defendant deserves the minimum possible sentence.
you take into account that from the get-go, Ms. Ferrona has been accepting of responsibility for her part in this case. Well, she certainly did something very wrong, and she does have a statement she's going to make for herself. When she was confronted with the police, she did help them find the firearm. She let them know where it had gone. Judge, from the first time I met her before her preliminary hearing, she said, "I will waive my preliminary hearing. I know I did something wrong. I'm not going to fight about bond." We had our first arraignment and pretrial. She's almost immediately said, "I will plead. I did something wrong." And Judge, especially in cases like this, especially with I don't want to demean the seriousness of her conduct, but certainly this started as an aggravated murder case. There's people in this matter charged with aggravated murder, and usually when you see the people charged with the lesser crimes, in my experience, those are the ones that hang on and say, "I didn't do anything, I didn't do anything." And Carla never did that. Your Honor, Carla's had an incredibly rough life. She has a dual diagnosis mental health issue as well as a serious substance abuse issue, her drug of choice being crack cocaine. She does know how to get herself in and out of programs, and she has worked them in the past. And I do expect that it is her intention to try to enroll in whatever courses are available to her, whether she ends up at Marysville, Dayton, or Northeast Ohio pre-release. And I hope, I'm not as familiar with the women's prisons, but I do hope she'll at least be able to get herself in a 12-step program and work it there. In part and parcel to the rough life she's had as a drug user and someone who's been in and out of jails, treatment facilities, and I believe prison, she also lost her child. Her son was in the custody of the Cuyahoga County Department of Children and Family Services. I think she had her parental rights completely terminated. However, she did maintain communication with her son, Christopher. Christopher had absconded from a group home in Cuyahoga County and became involved in this. And when he called her for help, I think she, in a bleak moment in time, just tried to do whatever she could do to help her son. And I think no matter what court orders say she is or isn't his parent, I think she'll always be his parent, at least in her heart. She went to the home. She went twice. On the second time, she found the gun in the bushes and then promptly took it back to Cuyahoga County, where
Now the courtroom shifts into one of the most emotional moments of any sentencing hearing, when the defendant speaks directly to the court. This is known as an allocution, a final chance for the defendant to express remorse, explain their actions, or ask the judge for mercy. These statements can be incredibly powerful because they allow the judge to hear directly from the person whose fate they're about to decide. In this case, the defendant appears visibly emotional and prepared a written letter. The question now is whether her words will convince the court that she truly regrets what happened, or whether the seriousness of the crime will outweigh any apology.
It was traded for a drug debt of somebody who I do believe that she believed was a ally of hers, but over the course of my representation, it's become clear to both Carla and I that the man for whom she traded the gun for his drug debt, was really using her.
For whose drug debt? For her drug debt?
It was
ex-boyfriend.
It was her ex-boyfriend, and she's happy to place his name on the record.
No, I didn't know if it was her debt or someone else's debt.
It was her ex-boyfriend's debt, Your Honor. And through the course of my representation of Carla, it became clear that, well, certainly that person was not responsible for Carla going into the bushes and Carla taking that gun. I do think she was, for some period of time, kind of under his thumb and under his control as well.
So this was her boyfriend at the time?
It was her boyfriend at the time. It was her boyfriend for even part of this case before it kind of all started to unravel. My experience with Carla is one of the best experiences I've had representing people in 13 years. She's polite. She's understanding. She understands the course of the conduct that brought her here. She understands the decisions she's making. She understands the reality of life, the reality that lawyers are lives, or that lawyers have lives, that judges have lives, that we are all people that are here to do a job. And that is an incredibly empathetic position to take as a criminal defendant, especially one with this dual diagnosis mental health issues. So with all of that, we would ask that you impose a minimum sentence. Thank you.
Thank you. Ms. Ferrone, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
Yes, I would like to read my letter, please.
Go
Your
ahead.
Honor.
You're
Okay.
gonna stand up.
Okay, so I was hoping that the family would be here today, Your Honor. I wanted to look them in the eye so I could let them know how I feel. I'm sorry, I'm shaking about everything myself. This is big. Okay, so anyways.
Want me to read it?
No, open to it. It says, first, that I'm glad that the family is here, but they are not. So I'm sad that they are not here. So I can look them in the eye and say that I know that there are no words or actions other than bringing their son back that could ever relieve the pain of losing the child, family, and friend in such a terrible way. And I'm sad for you all. I'm so sorry about your loss, and no matter what kind of mother I have been due to my use, I would be just devastated if it were my own child. There is not a night or a day that goes by that I don't play this over and over in my mind. And if I could take it all back and give it all back, and give your child back and fix everything for everybody, that I would. My life hasn't been that much. I would give my own life, Your Honor, if I could fix this and give a child back. I was high when the phone call came in, and I really did not know what to do. I was never told the details, nor did I actually go to Fox Run Apartments till the next day. Christopher did not call me to ask me to remove the gun. He thought the detectives that had already had it. I want to make that clear. I was there for something else. But when I did come across the bag, all I could think about was my own child. My judgment was clouded by the time that by the drugs that I was on, and the fact that I was on medication, on no medication to rationalize my first thought. When it all came together, the fear in so many forms set in. I've never dealt with a situation of this magnitude before, and I did not know that a young man had died. All that I could thought of at that moment was to help my own child. And now not only can I not be there for my child, but I've made his situation worse by my own deluded judgments. My mother died on December 4th, and I'm not there to help with the goings-on of her funeral, nor mourn the loss with our family. My sister Lori was in a nursing home for 3 years and finally came home. I was supposed to be there to help her with those things. Instead, my first thought was wrong. That quick. The consequences have not only been great for me, but for many others. I've been working for years on my addiction, mental health, and trauma. And when I fall, I instantly put myself back into treatment for my mental health or addiction.
The prosecution's argument takes a very different tone. While the defense focused on addiction and desperation, the state is emphasizing responsibility and criminal history. According to the prosecutor, this wasn't just a small act of evidence tampering, it involved removing a firearm used in a fatal shooting. That dramatically raises the seriousness of the crime. The prosecution also points out that the defendant has a criminal record going back decades, suggesting that previous prison sentences and treatment programs have not prevented further offenses. In sentencing hearings, prosecutors often stress these patterns to argue that prison time is necessary to protect the public and hold the defendant accountable.
2 years, Your Honor. I do not want to be the menace or a monster that I've been labeled. I'm actually one that cares for others. I want to one day help others with what I have been through. I have obtained my CDCA and I reach out to others when I can in many ways that you're not able to see, because all you're able to see, unfortunately, is the paperwork in front of you, which I want you to know, very embarrassed about. Please believe me when I say that I'm doing my best to heal. It is a daily reprieve, and yes, at times I struggle, but I always get back up and do my best to look at and find the positives in life that God gave me. I refuse to die a loser that has done nothing with her life. And unfortunately, this is not a situation that I can dust off in some kind of hospital or treatment to make it better. And I do take responsibility for my actions. Once again, and if you can let them know, I am very, very sorry to the family and friends. And whether they believe it or not, they are in my hearts and prayers continuously. And I am sorry for their loss. Thank you for listening.
Thank you. Ms. Corrigan, anything else?
No, thank you so very much, Your Honor.
For the state of Ohio, Ms. Tuttle?
Thank you, Your Honor. We're asking the court to impose a prison term in this case. The defendant does have credit for 158 days. She did plead guilty to the 1-year firearm specification. We would ask for a prison term consecutive on the underlying offense. The defendant has a
What do you mean
lengthy
consecutive?
to the firearm specification.
Oh, well, it has to be, all right.
Yes. The defendant has a lengthy criminal history starting in 1997, going all the way through the instant offense. There really is no substantial break in her criminal history. She has a number of prison terms that she has served. She's had a number of opportunities in treatment, and nothing has really proved to be successful for her. The facts of this case are more serious than the average tampering with evidence. The defendant knew that this gun was used in a shooting. Her son knew that that shooting led to the death of someone. Her son gave her information when he made a call to her immediately after this shooting happened. He told her that his friend had shot someone, that he tampered with a gun, that he cleaned it with Crown Royal, that he needed it to be taken away, that he did something bad, that he tampered with evidence. The defendant knew all of that and chose to come to the Fox Run Apartments, chose to get that gun from the location where he told her that it was in the bushes, and on phone calls to her son and her son's girlfriend said things like, I got it, it's taken care of, I've handled it, I got it. And she said things like that repeatedly. So the defendant knew exactly what she was doing and exactly what she was taking and what her son was risking as a result of his own conduct. The defendant was not actually separated from her child at the time that this occurred, Judge. The place where this robbery and homicide was planned was actually the defendant's bedroom in Melvin Harris's apartment. The defendant's items were all still in that apartment. They were all still there. She had been living with Mr. Harris at Fox Run, as well as her son. So they had been in communication. They had been talking with one another. All of her personal items were in that room where this homicide was planned.
He's still there.
The defendant was at the apartment only an hour before the Willoughby Police Department came to that apartment to search, to talk to people that were there, and to talk to her son. So she was there. She was retrieving items. She was retrieving evidence. Originally, she wasn't forthcoming and truthful with the police. It was once she didn't want to go to jail, she called the police back in and she began giving them truthful versions of events. But at first, the defendant was reluctant to tell them that she had any involvement, that she had any knowledge of anything. She told them that her statements of, I got it, were relating to getting an apartment, not about getting the gun that was under the bushes and the reason why her son was calling. So while I do understand and acknowledge that Ms. Ferrona wanted to do anything that she could to protect her son, that she wanted to watch out for him, that she wanted to be a mother to him, this was a serious crime that was committed using this firearm, and she had knowledge of that, which is why this is a more serious form of tampering with evidence, and we ask the court to impose that prison sentence. Additionally, we ask for count 2 of the indictment to be dismissed. Thank you.
There's a couple of victim impact statements that were sent in. I've read those. As for factors indicating the conduct is more or less serious, the court does note, as alluded to by the prosecutor, that the evidence that was tampered with in this case was a firearm that was used to kill a person. It was a firearm in a murder case. You know, the normal tampering with evidence case that we deal with is a person who's getting pulled over for a traffic offense and is getting rid of drugs that they have on them, throwing them out a window or trying to swallow them or whatever the case may be. Not necessarily, I think, the exact intent that that statute is designed for. Nonetheless, it's still a violation. But this, when people think of tampering with evidence, it's this scenario that people think of, and that you never get that. Hiding or getting rid of a murder weapon. And that's what this case is about. It's not just more serious, it's probably the worst form of the offense. Getting rid of a murder weapon. And interesting to me is that you said all you were thinking about was helping your son. We were also obviously thinking about helping your boyfriend, because you used that gun to then go take care and clear up a debt that he owed with his drug dealer. Instead of just getting rid of the gun, you took advantage of that, having that gun, to get some benefit to you and your boyfriend. Or at least him, but you helped him with it for that. I don't know how that'd be even a thought. I'll take this gun, but I know my boyfriend knows some money is this guy, so I'll give it to him and I can take care of that. No factors indicate it's less serious. As for recidivism factors, there's a lengthy history of criminal convictions. Goes back 30 years, 29 years. Defendant has served multiple prison terms before. She's been sentenced to prison on 5 separate cases that's resulted in 4 separate prison numbers. She's been on probation before in the past, has violated her probation on multiple occasions, so she's not complied with previously imposed sanctions ordered by courts. No factors indicate recidivism is less likely. It's mandatory prison term required due to the firearm specification. Prison's consistent with the purposes and principles of sentencing. Therefore, it'll be the sentence of this court. Then on count 1, defendant served a term in prison of 24 months. In addition, court imposes a mandatory prison term of 1 year to be served prior to and consecutive to the 24-month prison sentence for an overall term of 36 months in prison. First year being mandatory for the firearm specification. Need to advise you upon your release. You may be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. I will dismiss count 2, and I will grant the defendant 158 days of credit that she is entitled to at this point.
Your Honor, again, once again, can you guys just please
No,
tell?
they're not your messenger.
I just want to tell the family, I'm sorry.
Yeah, well,
They will.
Okay, thank you.
I will.
Thank you.
I'm not ordering that. You can do whatever you want. It's not part of this. Is there anything else, Ms. Tuttle, on behalf of the state?
No, thank you, Your Honor.
Ms. Corrigan?
Yes, Your Honor, would you please declare my client indigent and consider waiving her court costs on this matter?
No.
Thank you.
In the end, the judge concluded that this case represented one of the most serious forms of evidence tampering, the removal of a firearm used in a homicide. After considering the defendant's long criminal history, prior prison sentences, and the circumstances surrounding the case, the court imposed a 36-month prison sentence. That includes 24 months for tampering with evidence plus a mandatory 12-month firearm specification, which must legally be served first. The judge also warned that after release, the defendant could face post-release supervision for up to 2 years. This case highlights how even actions taken in moments of panic, especially when tied to violent crimes, can carry severe legal consequences. And now we want to hear from you. Do you think the sentence was fair? Was this a mother trying to protect her son, or someone who knowingly interfered with a murder investigation? If you found this courtroom case as shocking and thought-provoking as we did, make sure to like the video, share your thoughts in the comments, and subscribe to the channel for more jaw-dropping courtroom breakdowns.